Good afternoon, everyone. This is a lunchtime webinar on artificial intelligence and automated decision making in public bodies and what are the implications for housing cases. My name is Tim Baldwin. I'm a member of the housing team at Garden Court Chambers, and welcome to this webinar. This event, for your understanding, is being live streamed and recorded, and the recording will be uploaded onto our YouTube channel, and a link to the slides and the recording will be sent to our attendees or those who've signed up. If you have any questions during this webinar, please put them in the question and answer box, and our speakers and possibly even myself may endeavour to answer your questions towards the end of the seminar. We aim to finish at about 2 p.m. at the latest. So this webinar is designed to introduce housing lawyers and welfare benefit lawyers and caseworkers to the potential use of automated decision making within public bodies, and possibly how to challenge those individual systems when they use automated decisions. We have two very, very special speakers today. Louise Hooper, who's a barrister at Garden Court Chambers, who's primarily, as I remember, as an immigration and asylum lawyer, and she's going to speak to you particularly with how AI operates and examining how these systems work and the possible ethical problems they create, the fairness and regulatory frameworks, and how lawful decision making is supposed to operate within these systems. Dr. Susie Alegre is an associate member of Garden Court Chambers, and I'll talk to you a little bit more about her background when we get to her session. But she's going to look at the Dutch SYRI judgment and profiling and its implications for the UK, and the use of FOI and DASR in litigation, and accessing the Digital Freedom Fund for pre-litigation strategy. So hopefully what we'll be able to provide you with today is an introductory understanding to these systems, the risks they pose in terms of decision making, and the legislative and regulatory framework under which they're supposed to operate. Interestingly, this morning in the Prime Minister's speech about his government plans for the next election, he spoke of the advantages for the UK in AI. That might have been more of a Yossa Hughes type statement of give us a job to the general world, but it's prominent within government thinking as to the use of AI, especially in public bodies. So I'll turn now to the first session. What there's going to be is two speakers, first Louise and then Susie, and then I'll chip in a little bit towards the end as to how these possibly may be used in type of housing cases that you encounter. So our first speaker is Louise Hooper. She's a human rights barrister, and she's authored a chapter on AI and human rights in The Law of Artificial Intelligence in Harvey and Levy, second edition, 2023. Louise is an expert to the Council of Europe Committee of Experts on Artificial Intelligence, Equality and Discrimination. She's worked with Digital Futures Commission and Five Rights in the UK and UNICEF in the Balkans on child data and digital rights in education. She was an independent gender advisor to IT flows at EU-funded consortium developing migration prediction technology, and she's worked as an advisor assisting tech startups implementing human rights assessments. So we're very lucky that we can have Louise speak to us today. So I'm going to turn over to Louise for her first session. And when she's finished, I'll introduce Susie. Thank you.
So I'm going to do a brief run through AI and the DWP. And I'm going to look at three different things. Firstly, some definitions and methods in which bias enter artificial intelligence systems. Secondly, what we know about the use of AI in the DWP. And then thirdly, some discrete issues on data protection and human in the loop, and where data protection law is going in terms of automated decisions. So starting with some definitions, there aren't any universally accepted definitions. So I've put up two. The first is from the ICO in the UK. AI is an umbrella term for a range of technologies and approaches that often attempt to mimic human thought to solve complex tasks. Things that humans have traditionally done by thinking and reasoning are increasingly being done by or with the help of AI. That's one decision. A definition. A slightly more technical one comes from the OECD, and this is the definition that internationally appears to be gaining much broad acceptance. So this is a machine-based system that, for explicit or implicit objectives, infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Different AI systems vary in their levels of autonomy and adaptiveness after deployment. For our purposes, I include machine learning of all types within artificial intelligence. So supervised, unsupervised, and reinforcement learning, which can include deep learning and neural networks, logic and knowledge-based approaches, including reasoning and expert systems, and statistical approaches, search and optimization methods, and Bayesian estimation. And in the context that we're talking about, predictive analytics will be very important. Also statistical approaches, and at some point it may be necessary to get expert assistance on the techniques and methods that are used by software. That's quite a long way down the line, because the first issue is what's being used and what does it do. So a broad overview of some of the kinds of technology that use artificial intelligence that may be employed either now or in the future by public bodies includes surveillance technology of automated facial recognition, webcams, CCTV, computer use, including keystrokes, voice recognition, websites visited, contents created, semantic analysis of social media and that kind of thing. Emotion recognition technology, including facial expression recognition and lie detector tests, that kind of thing. And then profiling, which is probably the most important, as I say, for this area of work. Predictive algorithms have been used for sentencing, for recidivism assessments, in welfare fraud, which is the Siri case that Susie will talk about later, and migration and border control. Profiling is increasingly being used, and in safety tech in schools, or any combination of these things. In all of these systems, bias can enter into the system or the results at any or all of these points. The first one would be data collection. Data collection in and of itself is an inexact science. It depends on the questions that are asked by the data collector, the way that the data is collected and what it's supposed to represent. That data is then processed. And again, the questions that we ask of the data at that point can cause bias to enter the system. The way the model is developed and the way it's deployed can create further instances of bias, including feedback and confirmation bias loops that cause it to doubly impact the pre-existing bias. So once you put it into practice, it can build on pre-existing bias and cause an escalation. And the next slide looks at the different types of bias, which is a different way of looking at how it enters into the system, and describes this as historical bias, representation bias when you're collecting data, measurement bias when you're labeling data, so what you call it and what you say it's doing, how you combine it, the aggregation bias, what you ask it to do, selecting the metrics and objectives of the training data leads to evaluation bias, and then once you deploy it, again, that can lead to deployment bias. So all of those instances of bias are potential problems for artificial intelligence software and applications. So turning to the Department for Work and Pensions and the use of AI, we know that the government strategy is to increase the use of AI in government services, and that it sees this as, amongst other things, a sector for economic growth. So in terms of the DWP current use, Big Brother Watch did a report called Poverty Panopticon, and they identified these areas where AI is already being used. So risk-based verification, in-housing benefit fraud risk profiling, for rent sense and rental analytics, so to identify things like who's most likely to default on their rent, in digital care for older people, and then predictive analytics in particular were used for policy and practices low-income family tracker, Bristol City's Council's children's analytics to identify, amongst other things, children at risk, Hillingdon's Project Axis, which includes reference to the gangs matrix analysis, which has been subject to some quite significant criticism, and Zanshura's OneView, which looks at predictive analytics for homelessness and COVID separately from each other, but as two separate areas. And then the Public Law Project is tracking automated government and has a register of uses. And I think what comes out of these uses are two quite specific products. One is a risk assessment product, and the other is predictive analytics over fraud and error detection. So they are the Common Risk Engine, the General Matching Service, and Fraud Referral and Intervention Management System, and the 4 target areas of people living together, self-employment, capital, and housing. And the idea behind this is to flag claims for review by a caseworker. The fraud risk model, which is used to analyse universal credit, has come in for significant criticism. There's also a housing management system used in Wigan, which uses a points-based system for prioritising social housing waiting lists, and then Rent Sense. Again, this is the one referred to by Big Brother, which identifies social housing tenants at risk of failing to pay their rent. There is very little information about how these work, what data is used, or their ultimate reliability. But what we do know is that in all cases, the DWP appears to have identified a risk of bias, and the National Audit Committee, who did a report on this, identified that the risk of bias is inherent in these products. We also know that Mel Stride wrote to Stephen Timms on the 4th of December 2023, after the National Audit Committee had reported on the DWP's use of AI, in response to the question of how is AI being used, saying it's being used to identify vulnerable people from around 22,000 letters the department receives each day so that they can be prioritised. But again, it doesn't say how this is done. It could be through keyword tagging, it could be through semantic analysis. And then also trialling a lot of generative AI projects effectively to try and increase productivity and reduce work done by the department. Interestingly, what happened next was that OpenAI ChatGPT products were banned because they recognised that there is a real issue about privacy and data protection inherent in the use of those products that are available on the open market. In responding to the committee, one of the additional issues that came up was that Jonathan Jangley asked whether the investment in the AI project was value for money, given it was pulling up the same percentages of incorrect claims at a rate of about 30% as random sampling. And he asked, why the project? Why do you need to spend all this money if the result is the same as if you kept it random? And the department said, well, we're hoping it's going to be better in the future. The Public Accounts Committee has said that there are legitimate concerns about the level of transparency around DWP's use of these tools and potential impacts on claimants who are vulnerable or from protected groups. And it made recommendations about releasing information, considering explicitly the impact of data analytics, And the DUP responded saying that they can't provide information about the models used as this could be exploited by fraudsters. So some overall concerns relate to a clear lack of transparency, lack of fairness, lack of accountability, and lack of equality that appear to be embedded through the use of some of these products by the DWP. We also know that there's a poor record in responding to Freedom of Information Act requests. That, in my view, for reasons that I'll explain shortly, I don't think the privacy notice is transparent. And it's unclear if the tech works at all or sufficiently well to justify the extent of the surveillance. Some key remedies for individuals include the Equality Act, the Human Rights Act, some data protection claims or challenges, and potentially judicial review of policies and practices alongside traditional benefits type remedies. And I was asked specifically to consider the requirement for a human in the loop. So the law on a human in the loop comes from UK GDPR Recital 71 and Article 22. And this creates a right not to be subject to a decision based solely on automated processing where that decision has a significant impact on the individual. But it is subject to exceptions, notably where the automated decision is required or authorised by domestic law, which is frequently interpreted as including in relation to matters of fraud or tax evasion. And the requirement for human intervention itself is meant to ensure that individuals are not subject to potentially harmful decisions without human judgment and empathy. And the problem with it is, as Tim has identified, that you do end up with a confirmation bias where people are more inclined to just do what the computer tells them rather than take their own decision. But taking this as the starting point, what do we then know from what the DWP says about humans in the loop? And its personal data policy says DWP does not use AI to replace human judgment to determine or deny a payment to a claimant. But it doesn't say anything else about the possible uses of AI to make decisions within the benefits system. And there could be, as far as I can see, lots of other things that might be being done using automated decision making. It again says underneath this, will not make any decision based solely on automated processing, which has a significant effect on you unless the law allows this. And again, I think there is a gap in this policy, which doesn't explain fully where and how AI may be being used or automated decision making may be being used. But I could just be overly suspicious. I haven't quite decided which is the right version of those things yet. What I can say is that previously this policy read, most of the decisions DWP makes that have a substantial effect on you, for example, whether or not you're entitled to a benefit, are made with meaningful input from staff. Review or appeal options are built into all DWP benefit processes, even where this is not specifically required by data protection laws. DWP is developing new digital services all the time. So there appears to have been a slight change of emphasis. And given that DWP also will be making decisions about whether to investigate, whether to refer for fraud inquiries, and those types of things, it's not clear to me from this policy notice whether those things are covered or not. The DWCDP have said in Public Standards Committee in a follow-up to the report that was produced by the Public Standards Committee that they reiterated that no decisions to determine or deny payments are made with AI. And I think it's the repetition of determine or deny payments that is the thing that makes me wonder what else might be being done with AI that isn't covered, particularly because the information that was provided to the committee then goes on to say the Social Security Act 1998 Section 3 allows the DWP to pool information from customers and other sources for the purpose of functions relating to social security. So this is the combining of data with other government departments or other sources. Any external data comes with other legal protections from the Data Controller and other broader legislation like the Digital Economy Act or the Data Protection Act. The main legal data protection legislation for AI is the UK GDPR. And we know that certainly in the context of education, there's some excellent work being done by Jen Person at Defend Digital Me, looking at combination of data from education with other government departments and what the consequences of that might be. And I've put some references to some of those resources in the notes. So given that that's what the DWP's official statements are, you would think it would be quite easy to answer the question, what proportion of cases where AI has been used are subsequently checked by a human? But it appears that question is very difficult to answer, because the answer given was, I can give the noble lord some reassurance on the processes that we have in place. AI is an evolving iterative process, and it's important to highlight the fact that we have a test and learn approach. We must proceed with extreme caution in what we're doing. Test and learn means that we need to get to a point where we're assured that this will work and that nobody will be affected detrimentally. Then we can accelerate our programs. And I've looked at that 3 times now, and I cannot see at all how many people, how many decisions may have been checked by a human, whether it's all of them, none of them, or some of them. And that's Hansard, 5th of December 23. So what comes next? More joy with the Data Protection and Digital Information Bill, which is the got significant attempts to water down existing data protections. On automated decision making, the amendments will permit solely automated decisions on a wider basis than previously, and it waters down the human in the loop safeguards. It might be of particular relevance to welfare because of problems in the systems that can arise from innocuous data sets. So data sets that are not subject to the automated decision-making protection, but can lead to accusations of benefit fraud. And one of those arises from the Siri case, where household water usage was used to identify people. And then secondly, and perhaps of more immediate concern, is mass state surveillance through access to bank accounts, powers of search and seizure, powers of arrest, and civil penalties. It would see, in particular, banks being forced to scan customers' accounts in search of welfare fraud or errors, including the state pension and working tax credits, would reveal information about people's movements, opinions, and medical information. There are clear issues about breaches of privacy and equality issues arising. The ICO doesn't think this is okay, and neither do we. And I put in a reference to the Big Brother Watch briefing that's on this, which is available at that link. And that's my quick roundup to cheer everybody up on this Monday afternoon. Thank you very much for listening.
Thank you very much, Louise. At the moment, there don't seem to be any questions in the question and answer box, but feel free to put anything in during our next talk. Our next speaker is Susie. Susie is a senior public international lawyer and is recognized as an international expert on human rights, technology, and AI. She's currently a member of the Commission for Control of Interpol's files. She's advised organisations like the Equality and Human Rights Commission and the Centre for Data Ethics and Innovation. Susie's book, Freedom to Think, is Atlantic Book 2022, is listed as one of the technology books of the year 2022 in the Financial Times and the Daily Telegraph, and she was shortlisted for the Royal Society of Literature Christopher Bland Prize 2023. She has a new book out called Human Rights, Robot Wrongs, Atlantic Books, and that hit the shelves the beginning of this month. Also, Susie was referred to in an article in The Observer over the weekend on issues around artificial intelligence, and she can talk to this further. So without further ado, I'll turn over to Susie.
Thanks very much. Let me also now share my screen. Okay, well, following on from Louise's sort of broad approach about how the tech works and how we're seeing it in the UK, I'm going to dig down and look at one example judgment in particular from another jurisdiction, which will hopefully give some light as to how these issues have been and can be dealt with in litigation. So looking first at the global context, you might have seen in back in 2019, the UN Special Rapporteur on Extreme Poverty and Human Rights issued a report, the headline of which was that the world is stumbling zombie-like into a digital welfare dystopia. So he's clearly as positive as Louise is for this Monday afternoon exploration of where we're at. And I think it's important to bear in mind that his report, which warned about the dangers of the digital transformation of the state, where digital technologies are being used to automate, predict, identify, surveil, detect, target, and punish people, is now 5 years old. And so since that report, things have escalated rather than slowed down. And he flagged several issues in systems in countries around the world, including the UK, in particular universal credit. But as Louise has highlighted, we're seeing in the UK that these issues potentially come up in a wide range of different areas, particularly in the DWP field. So the case that I'm going to talk about today is the Siri case, which is a Dutch case. And Siri is a shortened version of what I don't have a great Dutch accent, but the Systeem Risico Indicatie, which was a Dutch legal instrument that essentially allowed the linking and analyzing of data from a wide range of government agencies with the goal of preventing tax and social security fraud and non-compliance with labour laws. So it was a very broad legal instrument that sort of provided a basis for this kind of linking and analysis of big data. So it allowed for projects to be set up called Siri projects, which then gathered data from across government and produced risk reports on individuals. When a risk report is filed, an individual is then deemed worthy of investigating with regard to possible fraud. So with regard to this question of the human in the loop, Siri, in effect, analysed big data to then flag people for the humans to then go and start investigating with regard to possible fraud. So it was a risk flagging system. Government agencies providing this kind of data included municipal governments, customs administration, social insurance bank, immigration and naturalization service, employee insurance agency, and supervisory authorities, including the social and employment inspectorate. And the kinds of data that were included, and Louise has mentioned even things like water usage data, but they also included information on health, finance, education, fiscal payments, employment, and integration. And essentially the idea was if you can gather huge troves of data and run them through automated systems, then you can get these incredibly smart flags that allow you then to focus on particular risk areas. In 2018, though, Siri found itself being challenged in court with a legal challenge brought by a coalition of civil society organisations in the Netherlands. I think it's very important that the case was brought by a coalition of civil society organisations because individuals who were affected, whose data had been involved in a Siri project, would only be informed when an investigation followed up on a risk report. So your capacity for even knowing that you might be affected was quite limited. And it was only when you got an investigation that you might have a hint that there was something going on in the background involving this kind of risk analysis of your data. The risk model, the indicators, the threshold values, the types of data, and the people targeted were not known to the individuals involved or to society at large at the time, and ultimately they were never actually known by the court. So all of these kind of details of how the sausage was made remained an unknown factor. But one important aspect was that the government confirmed that Siri was only ever used to analyze people in specific neighborhoods that they described as problem neighborhoods. So particularly neighborhoods with lower socioeconomic profiles, for example, and particularly immigrant populations in the Netherlands. So you can see just by the way the system was used and the populations that were affected, that you can already see that question of bias in the way it was being applied. In terms of the results of the case, and I'll talk a bit more about the judgment, the court did find that the Siri framework was a violation of the right to private life, and the government didn't seek to appeal the judgment. But what it did do was then follow up with new legislative proposals for automated decision-making in light of the judgment. And so it's important to see that much in the way that you'll see legislative frameworks for surveillance popping up out of challenges to opaque systems, it may well be that while cases might move forward the questions of transparency, you might then see governments continuing to legislate and continuing to be active in this area, but trying to fill the holes in the legislative framework for a bit more transparency. So the judgment came out in 2020, and it's very much a seminal judgment on these kind of issues in Europe. And it was a judgment from the District Court of The Hague. And as I said, they found that Siri was a violation of the right to private life under Article 8 ECHR. And it's important when looking at the judgment to understand that the way these things were argued and the legal analysis reflects very much Dutch law. And so while it was not based on GDPR or constitutional principles, it was very much an analysis of Article 8 of the ECHR, because that was the best way to argue these questions before the District Court of The Hague. The court did use the general principles of data protection from Article 5 of the GDPR to substantiate the requirements of Article 8 ECHR. So it's very much an ECHR case, an ECHR relevant judgment, but that then uses these broader data protection principles. In particular, it looked at the principle of transparency, the principle of purpose limitation, and the principle of data minimization to assess whether the requirements of necessity, proportionality, and subsidiarity in Article 8 were met. The lack of transparency as to what Siri was and how it operated also crucially led the court to decide that government secrecy itself added to the seriousness of the right to private life. And so secrecy was also a factor in assessing whether Siri was in fact in accordance with the law, and it referenced very much the Essen Marper against the UK case in Strasbourg, looking at the maintenance of large databases, particularly of biometric data in the UK. So again, going back to that question of proportionality and necessity. The focus of the judgment, rather than being on the question of legality, was very much whether or not Siri was necessary in a democratic society. And I think this is a really important aspect of the judgment, because ultimately this question of how far we want our public systems to be automated is a really serious question in relation to what is necessary in a democratic society and the way that our personal data is used and the impact that that has on the right to private life. And there were these references and connections with surveillance cases, in particular in Strasbourg, recognizing that they're not exactly the same, but there are certainly similarities and principles that can be drawn across from surveillance cases to these cases of automated decision-making based on big data. Some of the key points that the court commented on were the risk of discrimination compounded by opacity. the court recognised that there was a discriminatory impact, but it included that discriminatory impact and the risk of bias within its analysis of Article 8 without direct reference to Article 14 of the ECHR. So I think that's also an interesting aspect of the way the legal analysis was carried out in this judgment. Insufficient safeguards as well was another issue that the court flagged, noting that the legislation paid insufficient attention to the principle of purpose limitation and the principle of data minimization in violation of Article 2 of ECHR. And I mean, if you think about it, it's quite obvious that if what you're looking at is grabbing as much data as possible from as many sources as possible in order to run it through a machine, it's going to be very difficult to meet the principles of purpose limitation and principles of data minimization in that context. It also flagged that the legislation didn't provide for a comprehensive or independent review prior to the data processing in order to assess necessity, proportionality, and subsidiarity in light of all the files that are linked in a project, considering the specific purpose of that project. So essentially what it's saying is, you know, when you have a specific project or a specific reason for filtering and analysing all of this data, you need to think about the necessity, proportionality, and subsidiarity in that specific use case, rather than just a broad sort of anything goes approach to pooling data for this kind of analysis. It also flagged that government has a special responsibility when applying new technologies to strike the right balance between the benefits the use of such technologies bring as regards preventing and combating fraud on the one hand, and the potential interference with the exercise of the right to respect for private life through such use on the other hand. And I think what's important here, again, if you're looking at it on a specific case-by-case basis, is that while you may find arguments about fraud prevention, it's very important to see that this justification of fraud prevention or potentially protecting the rights of others is itself grounded in law that applies to the specific case that you are looking at. So it's not just an anything goes approach, will not really pass muster when looking at it through an Article 8 lens. So some of the key themes in the judgment are this interplay between Article 8 of the ECHR and data protection principles. And I think that's very important when you're considering specific cases, is how you can bring in data protection principles, how they may be useful in Human Rights Act arguments or Article 8 arguments more broadly, but also whether, you know, which forum is the best to use for challenging these issues. Discrimination and bias also has elements of privacy under Article 8 ECHR as opposed to discrete aspects, but as Louise mentioned, there may also be cases where the Equality Act is particularly relevant in and of itself. And I think it's also worth bearing in mind that the Equality and Human Rights Commission also does work in this space. Lack of transparency as well has its own legal consequences. So you can't just say, I don't know how it works, or I can't tell you how it works, and everything then magically goes away. Failing to explain or failing to say what's happening will in itself potentially lead to a violation of Article 8. And the absence of information might prevent substantive arguments, but it gives rise to arguments about safeguards and procedures. And so while the court wasn't able to look into the details of what was happening in this SIRI framework, that didn't prevent it finding a violation. Again, this interplay between the requirement for actions to be in accordance with the law and necessary in a democratic society in the legal analysis, you might well find that in specific cases, one or other or both of those aspects of the right to private life will come into play depending on the specific details of the case. And also, I think crucially, this need for independent prior risk assessments, which could potentially be a data protection impact assessment, human rights impact assessment, or an equality impact assessment. And so I think asking the questions about whether those kind of impact assessments have been done in specific contexts is important. Relevant UK legal frameworks, I think Louise has spoken a little bit about what's on the cards. I think it's very much a moving picture. It's very difficult to know where the law on these issues will be a couple of years from now. But I think there are various different frameworks we can use, including administrative law and human rights, and also Equality Act. Data protection law more broadly, although it remains to be seen what data protection law in the UK will look like following reforms, but also potentially the tort of misuse of private information may be relevant in certain cases in this context, because I think it's important to remember that data, however big it is ultimately personal data when it's being used in this context, and that is private information. So I think it's important to explore different ways that the law might apply to these practices. So looking then just very briefly at how to understand what's happening, which is incredibly difficult. And I think we'll often find in the context in this country, as they did in the Netherlands, that it's very difficult for individuals or even society at large to really understand what's going on and how you might be affected. And it may be that something happens to an individual, and it's only when something happens that you start asking questions and uncovering why it may be, for example, that they've been flagged for an investigation. So asking questions is incredibly important about understanding what's going on and whether or not one of these systems may have been involved in what's happened. Data subject access requests are sort of one way of asking on behalf of individuals, and there are time limit obligations and obligations to respond to data subject access requests. It's important when doing a data subject access request to keep it sort of narrow enough but broad enough to try to get the answers that you're looking for. So if you're asking for a data subject access request about an investigation, you can ask, for example, to have all of the personal data that was relevant to the decision to investigate this person, for example, to narrow it down. Otherwise, you may well find that a local authority will come back and just say they can't find everything because it's all too big and they've got too much data in too many different parts of the business. Freedom of information request is also a good way of going about things. It can be frustrating. You don't necessarily get the answers you're looking for, but again, a quite targeted freedom of information request, for example, asking a local authority what, if any, automated systems they use in welfare decisions or in housing, for example, and you may well then get information about companies that are contracted by them to do this kind of work, which will give you a bit of an idea of what might be going on. You can also look at things like the Information Commissioner Office reports. Increasingly, potentially, the Equality and Human Rights Commission may also have information on specific use cases. Media coverage, and I think Tim's going to mention something about that in a minute, but you might well find reports about things that are going on in specific areas, which can give a hint. Although I think media coverage, sometimes you can see things reported when you actually look into it. And I've had cases where you then put in a freedom of information request and it turns out the media coverage may not have been entirely accurate. And it's often difficult to know exactly where the information came from and what is correct. But these are all ways of sort of having attempting to find out what's going on behind the scenes, at least to know whether automated systems are being used, which then gives you an opportunity to look at these issues, even if you're looking at them from the perspective of a question of lack of transparency and being unable to really understand what's going on, and that is the problem. Civil society organisations, and I've listed a few here, but there are many, many more working on these issues, and they often have really impressive and detailed reports which can flag particular companies, particular issues, particular areas where they've identified problems, and they often do as well have a lot of technical information included in their reports. Privacy International is a very obvious one. Algorithm Watch. Foxglove does incredible work bringing legal challenges around the world on these kind of issues, and they're UK based. Public Law Project, as Louise has mentioned, and Big Brother Watch. Liberty also does work on these issues, and Reset is very much involved, particularly in advocacy around legal reform, Reset and Avowers. The Digital Freedom Fund, which was mentioned earlier, is also very useful, both in terms of looking at what other organisations or other lawyers are doing around Europe in this space. But the Digital Freedom Fund was set up to support strategic litigation around human rights in the context of technology. I understand they've recently got a call for applications. So I think there's a live call for applications at the moment. So it's worth checking out their website, and we can share that after the webinar. Importantly as well, the Digital Freedom Fund not only supports litigation, it also supports research prior to litigation. So I received a Digital Freedom Fund grant for pre-litigation research to look at the ways that the right to freedom of thought could be used in litigation to challenge some of these kind of tech systems, including some of the ones that Louise referred to. And so I think Digital Freedom Fund is a really useful source, as I say, both of information from people who've done this work before and sort of done some of the groundwork around Europe, but also as a way of getting funding to explore issues that you've potentially highlighted as areas of concern. As Tim mentioned, I have 2 books on this subject. If you want a layperson's introduction and a bit more general background, Freedom to Think specifically looks at questions around welfare and risk analysis, and Human Rights Robot Wrongs looks more broadly at the impacts of AI on our society. And I would be very happy to answer any questions when we move into the chat.
Thank you very much, Susie. I've just been asked to sort of tail this webinar with, well, how does this apply to housing cases in practice? Are there any examples, and where it might also apply either now or in the future? And it's notable that the local authorities are now cash strapped, and so they will be encouraged to use automated decision making much more in order to deal with issues of cost. And it's also instructive that it seems that the types of decision making that is aimed at is what you might call towards people on the sort of lower end of the socio-economic scale. I'm not seeing a lot of high levels of investment of AI in tax issues with the HMRC. Everything that I see to do with many concerns about this are related to either housing fraud, homelessness, or allocation of accommodation. And there was a recent article in a publication called My London on the 9th of May 2024 by Neil Shaw. And it's titled Councils Using Specialist Technology to Detect Housing Fraud or Potential Fraud. And this is set up by the South West London Fraud Partnership, and that involves 5 local authorities: Sutton, Merton, Richmond, Wandsworth, and the Royal Borough of Kingston. And what they have, what is said in this article is that they've reduced their analysis times by 90%, with reviews taking now only 10 minutes versus a long process involving manual examination. And what they have done is they've employed a company called Altia, and it's a financial investigation toolkit. And the plan is for this to be rolled out across the UK by this company to other council areas. And one of the aspects of the toolkit is that it's to automatically convert information into a clear digital format, and as well to enable them to identify entities, trends, relationship, and investigative avenues. So it's not just a data collection, it's a way of trying to find avenues of investigation and into relationships with other areas, for example, care issues, children issues, so on and so forth. And the idea is to automatically deal with things such as bank statements, housing benefits, or the electoral roll, and to create a system where they can check and analyze this information very quickly to allow them to build reports for cases which should be investigated further. So as described, the software uploads bank statements or other records into a format which is ready for analysis, and it also automates visualization of flows between accounts being investigated, showing size and scale. So this is what is described in respect of this this tool, and it said that it wants to also expand the use of such a tool beyond just these tenancy issues and housing fraud issues. And the idea is to provide a quick report, quick analysis. So that this is one example of what is reported. Admittedly, it's in a local newspaper, My London, but there's no reason to doubt that that isn't in operation already. And what we have as well is a potential for application of such tools to other areas of decision making within the housing world. We're all aware that what you have in allocation of accommodation and homelessness decisions is a structured process of decision making, either set out in statute, regulations and guidance, or set out in schemes for the allocation of housing. For example, in homelessness, you've got a structure where a decision has to be made as to a person's eligibility, whether they're homeless or not, whether that's intentional, and particularly on issues about priority need and a comparative analysis with other persons, and also making decisions about interim accommodation pending any review, and decisions around such things as giving somebody a relief duty, that is providing them with accommodation perhaps pending a final decision. And also a review process. So would a review process also be automated in terms of further evidence submitted? And you have that's in homelessness. With allocation, you have a structure around a published scheme, effectively a policy that creates prioritization for accommodation, and a reasonable preference issue, an eligibility issue, and also whether people would be accommodated out of borough or in borough according to particular policies. So in order to build something like that, you're going to have quite a bit of information from the past. But we know that even when policies and schemes and homelessness decisions are made, within existing policies and schemes, that errors do go wrong, bias is incorporated, and so that may be replicated or repeated within any automated scheme. And the difficulty is as well a complex link with housing and welfare benefits, such as existing housing benefit requirements as operated by district councils or borough councils, where they fall outside of universal credit, and also the examples of problems with universal credit entitlement that we've already seen. So who knows? It's there. It's likely to be applied already. And the question will always be is what level of oversight is there of an automated process and by an actual human being in a lot of these cases. So that's my sort of rough take on where it's likely to come in. It's going to be where you have a highly structured legislative scheme for decision making to remove the human element, to remove the reviewer, to remove the decision maker, in order to save money and save on assets. So I'm going to stop there. There's a question in the Q&A. It's from Generation Rent. And I'm going to put this to Louise and Susie. It says, is there a danger that biases and discrimination could already be baked into AI surrounding government decisions surrounding such things as benefit determination, housing allocation, especially surrounding things like race, ethnicity, and how could the government be held to account for this? Louise?
I'll be very brief on the first bit. The first answer is yes. And actually the DWP have already said that there is an issue of bias in their own data on benefits and things like that to do with age. One of the justifications they give for this is that people pretend to be over 25 so that they can receive more benefit, and that's one of the reasons why there are some problems with their data. But I think there are probably more problems within it than that. In terms of holding the government to account on it, one of the problems that we always find is getting data, including sufficient data to show where the discrimination is and how it arises. So that's the partial answer to the question. I'm going to hand over to Susie and see if she can do better on the second part of the question.
Well, on the first part of the question, yes, absolutely. And I think it will depend as well how things are applied. But what you'll find as well is that there will, it's very difficult to unpick. So obvious examples of bias and discrimination that might come out, for example, out of postcodes and particular areas, which then become a proxy for race or nationality or various other protected characteristics. That information will be going into the black box, and will then be producing results in that way. And I think the big question is constantly asking for explanations of how things are done. I think it will be interesting to see if the Equality and Human Rights Commission expands their work in this area. And I think that'll be a very good way to get a view, particularly on the bias, discrimination and Equality Act aspects of the problem. But definitely the problems will be there. And, almost by definition, these tools will be being used on people in lower socioeconomic groups, because those are the people claiming benefits, if you like. And so you will see definitely bias just by virtue of the kind of groups and areas where these are being targeted.
There's one more question. It's not really a question. It's from Kushal Sood, or Kush as I know him. I won't read it all out, but he's saying sort of, given that the NAO have acknowledged inherent harms of algorithmic decision-making, how do we mobilise the many decades of scholarship, especially in the fields of anti-blackness and related issues, to safeguard against development of AI in government in the first place? He says the danger is that the challenges will accept the legitimacy of AI without interrogating the foundational principles and instead end up co-opting its use. So it's a very philosophical type question. How do we use what we know already to prevent it being repeated within the use of AI, given everyone's sort of reliance or deference to it? Go ahead, Susie.
I mean, I think that is a problem. I think, and that's one of the things which, as I flagged with the Syria judgment, they found it to be unlawful, but then the government then just goes and tries to do it again in a way that supposedly meets the questions. And you see it happening a lot in Europe as well. Every time an agreement with the US is found to be unlawful by the European Court of Justice, then they'll go away and try and find a way around it to do what they wanted, but to sort of create the legislative framework. It's difficult, and to be very honest, that's why I've written books that are aimed at a lay audience, because I think it's something that is very much about societal awareness, and raising questions both in the legal field, but also in the political field, and also in our everyday activities. So yes, I think there are really big issues, and I think awareness of the issues is one of the steps towards addressing that, but it's a big challenge.
There's one. Louise, did you want to say something?
Just coming on that, I agree with Susie, but I also think that the genie's out of the bottle, and it's not so much accepting the legitimacy of AI itself, but trying to use the benefits that it can bring in terms of automating decisions that ought to be automated, or understanding patterns, whilst ensuring that it's not sort of techno-solutionism isn't adopted as a response to some of the social problems that we have, and some of the history and current issues to do with anti-blackness and racism. One of the things that we're working on at the Council of Europe on AI and equality is whether or not AI can be used positively to address some of those issues. And one of the things that I find continually surprising is that that AI holds up a mirror to all of the work that's been done in the past in many ways, and says, look how racist you were. And we're looking at that in surprise. And I think if the insights that can be gained from that could be used to our advantage, or to embed in challenges, for example, by looking at the data that we've got from previous decision making or previous outcomes, to challenge future legislation or outcomes as a result of that legislation, we may have some form of success in the face of something that I think is inevitable.
There are two more questions. There's a very general question from Mary A.O. and may not be able to answer this question. It's, where did AI originate from? Who caused the problem?
The answer to that is in my new book.
I think there's always been a form of AI, I think. Because originally computers were individuals, weren't they? And then it became a machine.
Yeah, I mean, the term AI was, I think it's in the 1950s in Dartmouth, US. So it's sort of it emerged out of a conference in the 1950s, the term artificial intelligence.
There's a final question here from an anonymous attendee. It says, we use data subject access requests on behalf of benefit claimants who are subject to targeted DWP fraud investigations, but the responses are of limited use in terms of revealing what prompted the investigation, though they may nonetheless be useful in helping us resolve the issue for the individual. Given the exemption for crime detection / prevention that is available to bodies responding to SAR, do the panel have any suggestions on how people can challenge the information they receive?
That is partly why I'd suggest also using freedom of information. So you can ask both a data subject access request and tailoring it specifically about whether or not, and how automated systems were used. So I think making a quite targeted data subject access request can be helpful. But at the same time, there's no reason why you can't also do a freedom of information request to say, what automated systems do you use in benefit fraud detection, and can you provide details? And that might be more useful, and then you can put the two together.
And that could be used, for example, with local authority housing departments across the country. People are concerned about this.
Yeah, and I think just making your questions quite targeted is useful for avoiding the sort of overwhelmed response, which is then not very useful.
Louise, do you have something to add? You look as if you're deep in thought there.
No, I was thinking about the surveillance and wanted lists for live facial recognition, and the similar difficulties that people were having in terms of subject access requests in finding out whether you're on a wanted list. And I was trying to work out whether there was a challenge to the system sort of overall rather than on an individual level, but that depth of thought hasn't quite come to fruition yet. So I'll carry on thinking about it.
Well, I think we're 7 minutes past 2, so I think we have to wrap things up now. I've been told to make you aware of upcoming events where tickets are available on the 14th of May 2024. It's an event called Upholding Children's Right, the implementation of the UNCRC, a comparison of England, Wales, Scotland, Northern Ireland. That's a hybrid event. And on the 15th of May, so the 14th is tomorrow, 15th is on Wednesday, part of the Neurodivergence webinar series, part 3, witness handling. It's an online event. So just to wrap things up, I'd like to thank all the attendees who joined us and stayed with us. We had a number of up to about 105 at its peak, and very thank both Louise and Susie for their really excellent insights into this area of law and how it may or may not affect housing cases and welfare benefit cases. We appreciate your feedback. You should get an online feedback form, and it will pop up when this webinar ends. And we ask you to fill this out because it helps us think about what your needs are as well as what our expertise is. And just to say, we'll send a link of the recording and the slides to you in due course once everything is processed by our marketing team. So again, thank you very much for attending, and thank you, Susie and Louise, for their expert input. So with that, I think we'll end today and everyone go back to work.